awareness mission along with the Institution Innovation Council of our college and IQAC of our college. What is this intellectual property? 2-3 വർഷം മുന്നേ എനിക്കും അറിയത്തില്ലായിരുന്നു എന്താണ് ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി എന്നുള്ളത്. ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റിഫർ ചെയ്യുന്നത് ദ ക്രിയേഷൻ ഓഫ് മൈൻഡ് സച്ച് ആസ് ഇൻവെൻഷൻസ് ആകാം, ലിറ്റററി ആൻഡ് ആർട്ടിസ്റ്റിക് ഡിസൈൻസ് ആകാം, വർക്ക്സ് ആകാം, ഡിസൈൻസ് ആകാം, സിംബൽസ് ആകാം, എന്ത് വേണേലും ആകാം. അപ്പോൾ ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ്സ് എന്ന് പറഞ്ഞാൽ ആർ ലീഗൽ റൈറ്റ്സ് ദാറ്റ് പ്രൊട്ടക്ട് ക്രിയേഷൻസ് ഓർ ഇന്നോവേഷൻസ് റിസൾട്ടിംഗ് ഫ്രം intellectual activities in scientific, literary or artistic event. The common IPR includes patent, നിങ്ങൾ എല്ലാവരും കേട്ടിട്ടുള്ളതായിരിക്കും, പേറ്റൻസ് കേട്ടിട്ടുള്ളതായിരിക്കും, കോപ്പിറൈറ്റ്സ് കേട്ടിട്ടുള്ളതായിരിക്കും, ജിയോമെട്രിക്കൽ ഇൻഡിക്കേഷൻസ് കേട്ടിട്ടുള്ളതായിരിക്കും. അതിൽ ജിയോമെട്രിക്കൽ ഇൻഡിക്കേഷൻസ് നിങ്ങൾ കൂടുതലായിട്ടും ശ്രദ്ധിച്ചിട്ടുണ്ടാകും. ആറന്മുള കണ്ണാടി, ദാറ്റ് ഈസ് എ എക്സാമ്പിൾ ഫോർ ജിയോമെട്രിക്കൽ ഇൻഡിക്കേഷൻ. GI എന്ന് പറയും. നിലമ്പൂർ തേക്ക് കേട്ടിട്ടുണ്ടായിരിക്കും അല്ലെ, കാഞ്ചീപുരം സിൽക്ക് കേട്ടിട്ടുണ്ടായിരിക്കും, ആൻഡ് ഡാർജിലിംഗ് ടീ, ഇതെല്ലാം ജിയോമെട്രിക്കൽ ഇൻഡിക്കേഷൻസിന്റെ എക്സാമ്പിൾസ് ആയിട്ടാണ് നമ്മൾ പറയുന്നത്. എന്റെ കർത്തവ്യത്തിലേക്ക് കടക്കുകയാണെങ്കിൽ I feel honored to welcome Dr. Punyan Kurian, Principal of St. Mary's College, Manarkad, to this webinar. Also, നമുക്ക് ഇന്ന് ഇവിടെ നമ്മുടെ സ്പീക്കർ എന്ന് പറഞ്ഞാൽ മിസ് അഞ്ജന ഹരിദാസ് ആണ്. Anjana ma'am is presently working as an examiner of patent and designs in Indian Patent Office, Chennai. She has completed her MSc in Integrated Biotechnology from Kerala Agriculture University in 2014 and has a research publication in her credit. She has 6 years of experience in the field of patents in the capacity of an examiner. So I welcome Anjana ma'am to this webinar on behalf of St. Mary's College, Manarkad, and all those who have gathered here. Also, I welcome all the teachers, non-teaching staff to this webinar. Also, students, നിങ്ങളാണ് ഇത് ശരിക്കും പ്രയോജനപ്പെടുത്തേണ്ടത്. എന്താണ് ഇന്റലക്ച്വൽ പ്രോപ്പർട്ടി റൈറ്റ്സ് എന്നുള്ളത്, എന്താണ് ഈ വെബിനാർ എല്ലാവരെയും പുറത്ത കുട്ടികളുണ്ടെങ്കിൽ അവരെയും സ്വാഗതം ചെയ്യുകയാണ് ഈ വെബിനാറിലേക്ക്. സോ മൂവിംഗ് ടു അഞ്ജന മാമിനെ ഡയറക്റ്റ് ആയിട്ട് ടെക്നിക്കൽ സെഷനിലേക്ക് ക്ഷണിക്കുകയാണ്. അഞ്ജന മാം, ഓവർ ടു യു.
Thank you for the warm welcome, sir. We'll go to the session. So I hope my slides are all visible to you. So
yes ma'am.
Okay. So I welcome you all to this National Intellectual Property Awareness Mission, NIPPA. This is a mission to make students aware of the intellectual property and how do you protect that. Adinana this mission is brought into to you is for this. This is to make you aware of the intellectual property. So, why is there this NIPPA mission? You can see this data. The 2019 patent application filing data. So, if you see, India's position is 7th. So, India, China, US, Japan, Korea, Europe, Germany. Why is it so? This is not because India there is no scientific community. It is because there is a lack of awareness of patents among the scientific community. So we have this mission NIPPA, National Intellectual Property Awareness Mission. This mission part item, we hope to make people aware of the intellectual property and the associated rights. So now we go to the session. We'll see in the session we'll be seeing what is intellectual property, what are the various intellectual properties that can be protected in India, and how do you go for the protection. Adana this session we are going we'll go through that, and this is a basic session where you'll be just given a basic awareness. So we'll go to the session. So before going to intellectual property, let's see what is a property. Property is something valuable that you own. this can be your car, your property ആണ്. It can be your house, that is also your property. അല്ലെങ്കിൽ it can be the mobile phone, that is also your property. Over some property you will have legal rights. ഇപ്പൊ കാർ അല്ലെങ്കിൽ ഹൗസ് അല്ലെങ്കിൽ ഒരു ലാൻഡിന് you will have the registration papers that will be in your name, so that indicates that the property is for you. So if someone encroaches that property, ipo nammade land arengle encroach cheyra, we can go to the court telling this is our property, this person has come and taken my property. So you have legal rights over some property. So property in general is something valuable that you own. Now in property there are two categories. One is tangible property, the other category is intangible property. Tangible property, we can touch it. Adinore physical existence ഉണ്ട്. അപ്പോൾ നമ്മുടെ വീട് അല്ലെങ്കിൽ നമ്മുടെ കാർ, so you can touch and feel it. So that is tangible property. Now അടുത്ത category ആണ് intangible property. Intangible property ക്ക് ഒരു physical existence ഇല്ല, നമുക്ക് touch and feel ചെയ്യാൻ പറ്റില്ല. For example, നമ്മുടെ goodwill അല്ലെങ്കിൽ നമ്മുടെ brand name, അതൊക്കെ ഒരു intangible property ആണ്. It's our property but it's an intangible one. No, it doesn't have a physical existence. You can't touch and feel it. നമ്മുടെ intellectual property ഈ particular category യിൽ വരുന്ന ഒരു property ആണ്. So intellectual property is an intangible property and it doesn't have a physical existence. So എന്താണ് intellectual property? Intellectual property it's a product of our mind. We are using our mind and creating something. So adana intellectual property. We creation or invention avan nammal endengalum pudhiya oru sadhana invent cheyunu. It can be that, or it can be a book you wrote, or it can be a art you drew. Allengi ningal design cheythu, you are a fashion designer, you are designing a dress. Our dress is your intellectual property. Allengi oru catchy one liner nammal kondannu, it can be that, like dil mange more Pepsi kinder. So that is a catchy slogan, that is the intellectual property of the person who actually coined that slogan. So intellectual property can be an invention, it can be a book you wrote, it can be the art you drew, it can be the design you made, or a symbol avam, you have created a symbol, or you have come up with a unique name or an image. Idakke avam intellectual property. Intellectual property rights are the legally enforceable right granted to the owner of intellectual property, and he rights sometimes for a limited period of time. So intellectual property is a creation or product of our mind, and intellectual property rights protect the intellectual property. So now we will see what are the intellectual properties that get protected in India. One, patents aanu. Patents are given for inventions allengi innovations. Ningal endengilum kandupidicha, that get patents. So patents for inventions or innovations. Designs. Designs are a visual appearance of the product. You are a fashion designer, you are designing a dress. A dress you can go for the industrial design protection. Then there is something called trademark. Trademark will protect the brand names. Ipo Tata, adu oru trademarked perayirikkum. Allengi oru Bata, Milma, idellam trademarked perana. So trademark protects brand names. Allengi adinte logo, symbol okke. Then we have geographical indication. Geographical indication oru particular sthalathu undavuna product ne indicate cheyyunnathaanu, and because of that place the product has its qualities. Like sir already mentioned, Aranmula Kannadi, it's a GI one. It is there. It is actually done by the craftsmen in Aranmula, and because of the craftsmen, the Kannadi has its own unique features. So it is a geographical indication. Then we have copyright. Copyright will protect books, allengi art, allengi drama, allengi the music you compose. Adana copyright. Then the last category is semiconductor integrated circuit layout design. This is an electronic era. Electronic devices have integrated circuit within it. The layout of the integrated circuit is protected by this particular IP, semiconductor integrated circuit layout design. So we'll be going to each one of these in detail, and we'll see how do you go for the protection of each one of these. Now, why should we protect our intellectual property? If you protect your intellectual property, it is now your own property. You can prevent others from exploiting the property without your permission. So you have a invention, and you can prevent others from using your invention without your permission. So you can exclude others. You can make use of that invention. You can commercialize that invention, and you can earn out of it. Let's say for corona, you found out a drug. So that is your intellectual property. A drug that treats corona. That is your invention. That is protected. You go for the protection of that. That drug is protected. You can prevent others from making your drug and selling it. You yourself can make the drug and sell it and take money out of it. So that is the importance and significance. I'll just show you an example. Why IPR is important. So you all know the smiley face. So in 1963, Harvey Ball drew a smiley face. And that smiley face he sold for $45. And that is for buttons and badges. He sold it for $45. He never went for the trademarking the design. So this was the situation in 1963 for Harvey Ball. But now there is Smiley World. It's a company. They have trademarked that particular symbol, and with that symbol they make around $250 million a year. So that is the difference between trademarking the symbol and not trademarking the symbol. Then another example is Facebook. You'll be all familiar. They recently went for a name change to Meta, but they couldn't get the name Meta just like that. In Meta was already trademarked by a South Dakota bank. So Facebook needed to get that name from the bank. For getting that name, they had to pay $60 million. So protecting our intellectual property is actually beneficial for the owner of the intellectual property. So now intellectual property we'll see in detail. The first one is patents. Patents are given for inventions, innovations. You are inventing something, you can go for the patent protection. So what is a patent? Patent is a legal contract. So legal contract, there will be two parties. One party is the inventor, the other party is the state. In India, the state is Government of India. So patent is a legal contract, and the legal contract is between the inventor and Government of India. And as a result of this legal contract, the inventor is getting exclusive monopoly. So this legal contract gives the inventor exclusive monopoly. Exclusive monopoly means he can prevent others from making, using, exercising, vending and importing his invention. So this exclusive monopoly is for a limited period of time. A limited period of time is 20 years. So getting this exclusive monopoly, he is supposed to give the complete disclosure about the invention. So he should be describing the invention in a detailed manner such that a person having an average skill in art, after going through his writing, should be able to reproduce the invention. So patent or a legal contract, the legal contract is between the Government of India and the inventor, and as a result of this legal contract, the inventor is getting exclusive right. This exclusive right is for a limited period of time, that is 20 years, and as a result, for getting this exclusive right, he is supposed to give the complete disclosure. He should be disclosing the invention in detail such that a person having an average skill in art can actually reproduce the invention after going through the disclosure. So what is a patent? It's a sort of certificate that the state gives to the owner of an invention. The patent gives him the exclusive right to exploit his invention. The term or life of a patent depends on the country. It's usually 20 years. Now, we'll see some famous inventions, inventors, and patents. this is something you'll all be familiar with. This is a dress pin, a safety pin. This had a patent. This is an invention. It was an invention, and in 1849, W. Hunt had it patented. So 20 years now, this was the exclusive property of W. Hunt. So, but a small thing can actually be a patentable invention. So this is one example. Then, when Thomas Alva Edison came up with the electric bulb in 1880, he had it patented. He had a US patent in his name. So this is another example. This was the first Indian patent. It was given to George Alfred D. Penny. This was given for a panka pulling machine. So this is the first Indian patent. Now, even patents were given for some weird invention like a rocking bathtub or mustache guard, etc. So inventions get patents, and inventions can be a product like that safety pin. It's a product, or it can be a process. Let's say a method of making a fertilizer composition. So inventions get patents. Inventions can be a product or a process, and these are the three criteria that actually make the invention patentable. One, new. New means this invention must be this should be the first time the invention is in the public domain. This should be something new. Simply you can't copy something and come for a patent. No, it should be new. The next one is inventive step. Inventive step means the invention should have a technical advantage or economic advantage over what is already there in literature. If you are actually, let's just say you are coming up with a new mobile phone. So that mobile phone must have some feature that is actually different, that makes it superior to what is already there in market. So you get patent for that. So it must be having an inventive step, and the invention must have an industrial application. Industrial application means it should be made or used in industry. So to be patentable, it should be new, it should be having an inventive step, and it must have an industrial application. So patents are given for inventions. The inventions can be a product or a process. Now, who can apply for the patent? The inventor can come, or his assignee can come, and if it is a deceased inventor, his legal representative can come and apply for a patent. The inventor can come alone and give the application, or he can join with others and give the application. Let's say someone from your college has invented something and he is coming for a patent application. He can come and do the application in his name, or he can do it along with the college name. Let's say Mr. X and your St. Mary's College together can come and do the patent application. So the inventor can come and apply for the patent alone, or he can join with others for the patent application. So what are the rights of a patent? So once you get a patent, you decide who may or may not use the patented invention. You can provide permission, or you can license the patent to some other party to use the invention on mutually agreed terms, or you can sell your patent to someone else on mutually agreed terms. So these are the rights. You may decide who may or may not use the invention. You can provide permission or licenses, or you can sell the right to someone. Now, when should an application for patent be filed? So the application should be filed at the earliest possible date without any delay. Your invention, if you have an invention with you, next step is go on and file a patent application. You should not wait and do a delay there. You should do it without delay. So the scientific community, what is the approach normally is, if they have a research finding or an invention, what they normally do is they go for the publication first. Then they come for the filing of patent application. That is not recommended. It's always recommended that you come and file your patent application first. Later you go for the publication, use or share. And you need not wait for the invention to be fully developed. if you have a small idea or a small prototype, you can file the patent application with that basic idea. You will be given a time of 1 year to complete your invention, and then you can file your complete application. So even if it's a basic idea you are having about an invention, you can file your patent application. You will get a time period of 1 year to file the complete application. Now, what is the patent filing and prosecution procedure in India? There are two ways of filing patent application. You can come to the patent office and do the physical filing. You can write, print it in papers. You can come and submit in the patent office. That is one option you have. The other option is e-filing. You can do the online filing of your patent application. So once the office receives your application, the office will be giving you an application number and date of filing. With this application number and date of filing, you can do the, you can track your application. You can check the status of your application with this application number and date of filing. So this is the step. You can come and do the hard copy filing, or you can do the e-filing. So there is something called as territorial jurisdiction. That is, if you are doing your invention in Kerala, you need to come to Patent Office Chennai to do your patent application filing. Actually, we have 4 patent offices, 4 metros we have each office. So we have one in Mumbai, one in Chennai, one in Delhi, and one in Kolkata. If you are an inventor from Kerala, or you are doing your invention in Kerala, you need to file your patent application in Patent Office Chennai. So Patent Office Chennai actually takes care of the filings from the states of Andhra Pradesh, Karnataka, Kerala, Tamil Nadu, Telangana, Pondicherry, and Lakshadweep. Now, so how do you file your patent application? What are the necessary forms, and what is the fee associated? So the basic form that you should fill is, there is a Form 1. Form 1 is a basic form where you will be giving the details of the application, applicant, etc. You will be giving the name of the invention, name of the inventor, contact details of the inventor, etc. So it's a basic form where such details will be given. And there is a small fee that is associated with Form 1. So you need to submit Form 1 along with the necessary fee. Then the next form is Form 2. Form 2 is the important form where you will be describing your invention in detail. You will be giving the title of your invention. You will be giving the background of the invention. You will be describing the invention with examples, drawings, etc. And the description should be in such a way that a person, after reading, he should be able to recreate the invention. So in Form 2, you will be giving the details of the invention. Then another form is Form 18. It is the form that is given for requesting the examination. That is request for examination. You can file that form within 48 months after filing your application. But once you file this particular form only, the application will go to the next process. That is, it will come to the examiner for examination. And there is a fee that is associated with Form 18. So the main forms are Form 1, where you will be giving the details of the inventor, detail of the inventor, contact details of the inventor, name of the invention, etc. That is Form 1. Then there is Form 2, where you will be describing your invention in detail. And there is Form 18, where you will be requesting for examination. So this is the fee that is associated with the patent application. If you are a natural person, that is a single person, or you are an educational institute, you need to pay around 5,600 for filing a patent application. So now I'll share with you what actually happens in the office once you give your application. So you have submitted your application in the office. You can do the provisional application. I told if you have a small idea also, you can come with a patent application filing. You have filed that, or you can file the complete application. So you have filed your application. Office will be giving you an application number and date of filing for your reference. Then 18 months, a wait period of 18 months is there. After 18 months, your application will get published in the official journal. So once it is published, it is in the public domain. Anyone can see your application. So people will go through the official journal, and if someone have an objection with respect to your application or opposition with respect to your application, they will communicate the same to the office. Then if you have filed the form 18, that is request for examination, your application will come to an examiner for examination. The examiner will go through your application. He will see whether the invention you are asking for patent is new, whether it is having an inventive step, whether it is having industrial application. These three factors are checked, and based on that, the examiner will give you a first examination report. First examination report is sent to the applicant. The applicant will again go through the report. He can do the necessary modification in his invention, or he can give his reasoning. And he will be sending the reply to the first examination report back to the examiner. The examiner will again go through the reply, the invention, and it is finally decided whether to go for the acceptance or rejection of the patent. If still there are some objections, the same will be communicated to the applicant, and the applicant will be given a chance of oral hearing. And after the oral hearing, that is, we talk to each other and finally it is decided whether the application is to be granted or rejected. So it's nothing. You file your application, after 18 months it gets published. Then it goes to an examiner for examination. The examiner will go through the application. He'll give you a first examination report. The applicant will go through the report and he will do the necessary modification or response to the examination report. The examiner will again go through the report, and it is finally decided whether the application is to be granted a patent or it's to be rejected. So once your application is given a patent, you get a grant certificate like this. That is a patent certificate, and that invention is your exclusive monopoly for 20 years from the date of filing. So this is the patent certificate, grant certificate. No, that is with respect to the first intellectual property, patents. Now we'll go to the next one, designs. Designs are normally given for the visual or ornamental or aesthetic aspect of an article. Let's see this bottle. We just see the bottle with our eye. That's it. What is the speciality that we see with our eye is only considered in industrial design. The external feature appealing to that. Ipo ee car there is some designs in this car. That is also a subject matter of industrial design. This has nothing to do with the function of the article. We don't see what is the function of this bottle or what is the function of this car, nothing. It's just the feature that is appealing to our eye. So the feature can be a new shape. This bottle is a particular shape bottle, or it can be the pattern. Let's see, this car pattern is also the subject matter of industrial design, or it can be the configuration. So it can be patterns, lines, or colors. So if you are a fashion designer, you are designing dresses. Each of these dresses actually qualify for the industrial design protection. Now, the shapes of the bottle. If you have shampoo, there are multiple bottles. So each of this bottle actually qualifies for the industrial design protection because one bottle no one shape on. So each one qualifies for the industrial design protection. Now, industrial design is normally given for 10 years. You can renew it for another 5 years, but totally 15 years. Your design is your property. You have the exclusive right over your design. So how do you go for the design application filing? Patent application you can do the physical filing or you can do the electronic filing. Physical filing you need to come to any of the IPO and give your application in as a hard copy. If it is e-filing, you can use your computer and do the filing. Design applications are dealt in Intellectual Property Office, Kolkata. Dedicated examiners are there in IPO, Kolkata. They will do the examination, registration, publication, post-registration works. So, wherever you file your application will be directed to Intellectual Property Office, Kolkata, and the examiner there does the examination of design application. So, what are the requirements to file a design application? The first one is the application fee. It is around 1,000 rupees for an individual or a startup. And there is application form one where you'll be giving the details like contact details of the applicant, all that. Now, since it's just a visual aspect that we consider here, you are required to give 2 sets of representation illustrating the various view of the article. Article the pala view representations are required. So these are the basic requirements: the application form, application fee, and representations illustrating the various views of the article. Now, once you get your design approved or registered, you get the certificate of registration of design like this. It is initially given for a time period of 10 years. You can renew it for another 5 years. So your design is actually protected for a period of 15 years. Now, if you have a design protected, you can actually mark the article with registered or REGD or RD along with the registration number. This will actually deter infringers and help you in the legal action. So, if a bottle design we register, we can mark the bottle with registered symbol along with the registration number. Now, the next IP, the third IP is trademark. Trademark is a sign that is capable of distinguishing the goods or service of one enterprise from those of the other. This random pizza providers are. Let's say Pizza Hut, Domino's. So both of them have their own symbols. So just seeing the symbol, you can tell, okay, this particular pizza is from Pizza Hut, or this particular pizza is from Domino's. And these three are shoe brands or shirt brands you get. So just seeing the symbol, you will be identifying, okay, this particular product is from this brand. So a sign that actually helps you to distinguish the goods or service of one enterprise from those of the others is actually the trademark. Now, Blue Dart, Indian Post, FedEx, they are courier services. Just seeing that brand name or symbol will help you to identify, okay, a service provider. So such a sign is called as trademark. So what is the subject matter of the trademark? It can be the brand name. Let's say LG or brand name, Nike brand name, McDonald's brand name, KFC brand name. That is the subject matter of trademark. It can be the tagline like Amul, the taste of India. That is the tagline. Just do it. Life's good. Because you're worth it, I'm loving it, etc. It can be the tagline or slogan, or it can be the sound mark. Like you would have noticed when MGM picture starts, you hear a lion roaring. It is the sound mark. Or the Britannia ads come, they have a music that is associated with it. That is also the sound mark. It can be logo, like McDonald's is having some yellow, red color combination. So it can be the logo. So the subject matter can be all of this together. So the subject matter of trademark include brand names, tagline, sound mark, or logos, and a combination of all these. Now, how do you indicate your trademark? If you have a brand, you have applied for the trademark protection, you can indicate it with TM. Or you have it already registered, you can indicate it with the R. Now, the trademark registration is actually optional, but if you go for the registration, you get your own advantages. It is initially given for 10 years. You get your trademark protected for 10 years, but you can renew it further. Indefinite renewal is possible, but you will be given like 10 years protection. After 10 years, you need to come and again renew. So in case of non-use or non-renewal or no policy, the rights are lost. And the registration is governed by the Trademarks Act and trademark rules. Now we'll go to the next one. I think this is the fifth IP, that is copyright. Copyright is given for literary work, books, drama, the music you compose, the art you draw. All this can be protected with copyright. So once the owner gets the copyright, he can decide how his work is to be made available to public. Suppose you have written a book and you got a copyright for the book. Now you can decide which publisher should I go for publication of my book. So that is your decision. And you can prevent others from copying or reproducing your copyrighted material without your permission. If you have composed a song, you can tell, no, don't copy my music. You can do that. Copyright cannot protect an idea. It can protect the expression of an idea. Simply, if you have a music within you, you have the idea, that idea cannot be copyrighted. You should be recording it in some kind of medium. Then that particular thing which is recorded in a medium can go for the copyright protection. So what are the criteria for a work to be copyrighted? The work must be creative. Some creativity in that. It should be original. You should not copy it from somewhere and go for the copyright protection, no. And it should be fixed in some kind of medium. If it's a story, you should write it in a book. Or if it's a music, it should be recorded in a recording device. So these are the criteria. It should be creative, it should be original, and it should be fixed in some kind of recording medium. Now, what are the subject matter of copyright? It can be the books you write, literary work. It can be the paintings you make, or the drawings you make, or the photographs you click, the films you make, the music you compose, the choreography you do, the sculpture you do. So all these are the subject matter of copyright. So if it's a book, the author is the owner of copyright. If it is a music work, the music composer is the owner. If it is an artwork, the artist is the owner. If it is a photograph, the photographer is the owner of copyright. If it is a film, it is the producer who is the owner. Now, how do you do the copyright application? There is something called as Form 14. You need to fill that form, and along with that form, you need to give your copyright material. Suppose if it's your book, you fill Form 14 and you give the copy of your book, and you will file the application in Copyright Office, New Delhi. You can do it in person, or you can send post, or you can do the e-filing. So along with the payment, there will be some associated fee. You need to do the payment. So what is a term of protection? So if it is a book, the book is actually protected for the time period, that is life of the author plus 60 years. The book is under copyright protection. This is the same when it is a musical work or an artwork, etc. If it is a film, the copyright is actually 60 years from the date of publication. If it is a performance rights, 50 years from the year following the year in which the performance is made. So this is the term of protection of the copyright. Now, there is a fee that is associated. If you have a book and you need it to get copyright protection, you need to pay around 500 rupees for the copyright. Or if it is a film, it is 5,000 rupees. Now, the next type is semiconductor integrated circuit layout design. ഞാൻ ആദ്യം പറഞ്ഞത് ഇലക്ട്രോണിക് ഇരയാണ്. ഇലക്ട്രോണിക് ഇരയിൽ മൾട്ടിപ്പിൾ ഇലക്ട്രോണിക് ഡിവൈസസ് ഉണ്ട്. ഈ എല്ലാ ഇലക്ട്രോണിക് ഡിവൈസസിലെയും ഒരു കോമൺ ഫീച്ചർ ആണ് ഇന്റഗ്രേറ്റഡ് സർക്യൂട്ട് വിത്തിൻ ഇറ്റ്. ഈ layout of the integrated circuit within the electronic devices is protected by this particular IPR, that is semiconductor integrated circuit layout design. Our registry, semiconductor integrated circuit layout design registry, is in New Delhi. You can submit your applications there, and once you submit your application, if it gets approved, your layout design is protected for 10 years. So this is the term. Now, the last one I'll be discussing here is geographical indication. So geographical indications are called as invaluable treasures of incredible India, or Atul Bharat ki Amulya Nidhi. So a geographical indication is an indication that identifies a product that have a specific geographical origin and possesses quality or reputation that are due to the origin. Another example, Palakkad Matta. Palakkad Matta is grown in Palakkad, and because of the climatic conditions here or the soil there, the rice has its own qualities or reputation. So you can't get the same quality or reputation when you grow it somewhere else. No, you take the rice and you grow it in Coimbatore, you might not get that same quality. So the area is actually contributing to the quality or reputation of the product. അപ്പോൾ അങ്ങനെയുള്ള പ്രോഡക്റ്റിന് കിട്ടുന്നതാണ് geographical indication. For example, Tirupati Laddu. That is actually some speciality of Tirupati temple. You get it there only. That is one example. Let's say Marayur Sharkara. That is also an example. Vazhakulam pineapple. Aranmula Kannadi. Then Balaramapuram handloom. Kanchipuram silk. All these are GI. So let's see some examples like Edayu chili, Mysore sandal soap, Nilambu teak. The product actually have its quality because of its origin. Place of origin actually contributes to the quality or properties of the product. Now other examples are Darjeeling tea. Darjeeling tea was the first Indian product to be granted GI protection. Then we have Kanchipuram silk of Tamil Nadu. Then we have Cheriyal painting, Balaramapuram sari, etc. Now, agricultural product also qualify for GI protection like Vazhakulam pineapple, Kashmir saffron, Coorg orange, Nagpur orange, etc. Now, so that was the end of the session actually. Now we'll do a summary. That is, these are the various IPs that get protected in India. These include patents, designs, trademark, copyright, geographical indication, and semiconductor integrated circuit layout design. Patents are given for inventions or innovations, and the term of a patent is 20 years. Then we have the design. Design is with respect to the visual aspect of the article. It has nothing to do with the functional feature of the article. The term of protection is 10 years. You can renew it for another 5 years. So your design is actually protected for 15 years. Then there is trademark. This particular trademark protects the brand name or logos or symbols that will identify or distinguish goods or service. The protection is indefinite, but you will be given initial protection for 10 years. After 10 years, you can renew it for another 10 years. Then we have copyright. It is for artwork or books or musical work or films, etc. So the protection is actually lifetime of the author plus 60 years. Now we have geographical indication. Geographical indication is given to a product from a specific location having qualities because of the location. The protection is indefinite, but initially it is given for 10 years. After 10 years, you need to renew it. Then we have the semiconductor integrated circuit layout design. This is for the layout of integrated circuit within the electronic devices, and the protection is for 10 years. Now, sometimes a single product might have multiple IPs associated with it. Let's see an example. So this is Apple MacBook. So this is having multiple intellectual properties associated with it. The LED display. This is an invention, and LED display can be actually protected with a patent. Now, the body of the laptop, the shape of the laptop can be protected with industrial design. The Apple sign here is the subject matter of trademark. Then the user manual, it is a written material that can be copyrighted. The layout of the IC within the laptop is the subject matter of semiconductor integrated circuit layout design. So a single product might have multiple IPs associated with it. With that, let's see another example, or a pressure cooker. The pressure cooker, the inventions that are relating to the constructional feature of the cooker. Let's say the safety valve mechanism of the cooker is actually protected with a patent. The design of the cooker, let's say the shape of the cooker or the shape of the handle, the shape of the lid, etc., is a subject matter of industrial design. The trademark will be protecting the name. Let's say Prestige, Hopkins, etc., can go for the trademark protection. So what are the points to remember? Whatever is your IP, first come and protect the IP, then go for the publication. Then all the rights are territorial. Initially, I told the rights are given by the government of India. So the rights are limited to the boundary of the country. If you get the right in India, your product is protected in India. If you want it to be protected in some other country, you need to go and approach the authority there for the protection. The registration is done by the sovereign authority. In case of India, it is the government of India who is giving you the protection. And the rights are for a limited period of time. We have already seen patents are for 20 years, designs are for 15 years, etc. Then there is no automatic relief. If you have an invention, you have it patented, and you see someone using that without your permission, nobody will put a court case against that person who is using that. You need to do the steps. You need to file the infringement suit and get relief for unauthorized use. And there are renewal fees associated with some intellectual property. Now, normally what we see is, if it's a patent application, the inventor, what he does is he normally approaches a patent agent for filing the application. That is not always necessary. The inventor can himself sign and file the application in the office. Now, what can you do in this particular field of intellectual property? The first option you have is, you can be an inventor, or you can be a designer, or you can be an author or an artist, or a filmmaker, etc., musician, and you can do the filing of patents, designs, copyright, etc. That is one option that is there with you. Then another option is, you can become a patent agent. To be a patent agent, the minimum qualification is that you should be a graduate. And the next thing is, you need to study the Patents Act 1970. After studying the act, you need to appear for an exam that is conducted by Government of India. If you successfully pass the exam, you will be registered as a patent agent. Once you are a registered patent agent, you can help inventors file their patent application in patent office. So that is the patent agent. You can be the patent drafting specialist. Patents have a specific format, so you need to draft your application in that particular format. So you can help inventors in drafting their application in that particular format, or you can be a patent analyst. You can do the analysis. You can work in trademark copyright firm. To work in trademark or copyright firm, you need to have a law degree. And nowadays, all the research institutions have their own IPR cell. You can actually work there in the IPR cell. You can actually be in the IPR policy making, or you can join the government IPR office. You can join as an examiner of patents and design, or examiner of trademark, examiner of copyright, etc. Now, so these are our 4 offices. As I already mentioned, we have 4 offices in 4 metros, one in Delhi, one in Chennai, one in Mumbai, one in Kolkata. And in Nagpur, we have our training institute. So this is the Rajiv Gandhi National Institute of Intellectual Property Management, Nagpur. They normally give trainings on IP, IPR. If you need any further training, actually you can go through their website and appear for the training. Now I'll give you I'll list out a few organizations or schemes that will actually help you if you need to go for the protection of your IP. One such organization is Intellectual Property Right Information Center Kerala, IPRIC of Kerala State Council for Science, Technology and Environment. They actually give awareness of IP, IPR, etc. They assist inventors in protecting their invention and creative work through appropriate form of IPR, and this is one organization that will actually help you if you have to go for the protection of your IP. Now there is a scheme called as Kapila scheme, that is Kalam Program for IP Literacy and Awareness. This is a scheme that actually give you funding assistance if you need to file a patent application. So this scheme is there. Then we have the National Research Development Corporation. They also provide IP consultancy services. So these are some of the organizations and schemes that can actually help you if you have a IP and you need to go for its protection. There are many more. I just quoted a few examples. You can actually go through them and you'll understand in detail. So that was the end of the session. Now I have a small quiz. This is based on what I have already discussed. You can unmute yourself and answer, or you can type the same in chat box. So let's go to the first question. So some famous trademarks are hidden in the script. Can you spot them? So I think you can give the answers in chat box, or you can unmute and speak. Amul is there. Very good. Tata, very, very good. Then what is that? Dettol, Horlicks, yes. Pepsi, yes, Pepsi is there. Then what is something? I'll also help you in finding. Lux, yes. Yes, yes. Now next one. Bata, very good. Now. Yes, Bata is there. Now I think you just missed one. There's some chocolate company is there. Can you see that?
Cadbury.
Yes, Cadbury is there. Very good. So I think you found almost everything here. So we'll see. You have spotted Pepsi, Cadbury, Amul, Tata, Dettol, Horlicks. I think you just missed Babool, Bata. Everything is spotted. Now the next one, you should tell me what is the IP associated with each one of these. The first one is a painting. So what is the IP that is associated with the painting? Painting and the IP protection we can go. What IP protects the paintings? Very good, Manasa. It's copyright. Super. Now next one. The second one, oru Sheila, that is also an artwork. So what kind of protection? Which IP protects this? Oru sculpture. Oru Sheila. So what is that? Shilpam. Oru creative work. So what is the IP that is associated with that? So that is also a copyright. So this is a artwork. The first one is a painting. 1 and 2, it's copyright. Now we'll go to the third one. Third one is an apple symbol evident. We have a MacBook or iPhone or iPad. So what IP comes to your mind?
Patent.
Patent, yes. The technology can be patent protected. But what about the symbol here? What protection will this get? Design protection pattum correct aanu oro shape pattern on. Yes, trademark. Apple symbol trademark. Yes, very good. Now fourth one oru brand name aanu. Bisleri. Adine endu protection aanu brand name. Brand name is trademark protection. Now the fifth one oru bottle aanu kanna. Bottle endu protection we can go for what kind of protection for this bottle? Fifth one. Design, very good. So നമ്മൾ നോക്കുകയാണെങ്കിൽ 1 and 2 it is copyright. ഇത് രണ്ടും ആർട്ട് വർക്ക് ആണ്, ക്രിയേറ്റീവ് വർക്ക് ആണ്. So painting and sculpture both come under copyright. The next one we have a MacBook, iPhone, iPad. The Apple sign here can be trademark. The technology is a patentable invention. പിന്നെ ഇതിന് അതിനേതായ ഡിസൈൻസ് ഉണ്ട്, so that can be protected with the industrial design. Fourth one ഒരു brand name ആണ്. Brand name is actually the subject matter of trademark. Fifth one ഒരു bottle ആണ്. The bottle can qualify for design protection. Now the next one, which type of IP protects the painting painted by artist? Copyright, geographical indication, patents, designs, trademark. Yes, copyright. Very good. Now the next one is, what protects the intellectual property created by fashion designers? Copyright, GI, patents, designs, trademark. Very good. Designs. Fashion designer designs are protected with the industrial design. പിന്നെ അതൊരു കാര്യം, ഇപ്പൊ ഫാഷൻ ഡിസൈനർ ഒരു പേപ്പറിൽ ആ ഡിസൈൻ വരയ്ക്കുകയാണെങ്കിൽ അതൊരു ഡ്രോയിങ് ആണ്. ആ ഡ്രോയിങ് വിൽ ബി എ സബ്ജക്ട് മാറ്റർ ഓഫ് കോപ്പിറൈറ്റ്. ഇപ്പൊ ഫാഷൻ ഡിസൈനേഴ്സിന്റെ വർക്ക് പ്രൊട്ടക്ട് ചെയ്യാൻ രണ്ട് IP ഉണ്ട്. ഒന്ന് ഓഫ് കോഴ്സ് ഡിസൈൻ ആണ്, ആ ഡ്രസ്, ആ ഫിസിക്കൽ ഡ്രസ് ഇസ് ദ സബ്ജക്ട് മാറ്റർ ഓഫ് ഡിസൈൻ. പക്ഷെ അവർ ആദ്യം ഡിസൈൻ ചെയ്യുന്ന മുന്നേ ഒരു പേപ്പറിൽ ദേ ഡ്രോ ദ ഡിസൈൻ. ദാറ്റ് ഇസ് ആക്ച്വലി ദ സബ്ജക്ട് മാറ്റർ ഓഫ് കോപ്പിറൈറ്റ്. Next question. What protects the advanced disc brake for the bike developed by inventors? Copyright, GI, patents, designs, trademark. ഒരു advanced disc brake ആണ്, ബൈക്കിന്റെ ഇൻവെന്റേഴ്സ് ആണ് ഡെവലപ്പ് ചെയ്തത്. What is the IP associated here? Patent. Very good, Adra. Patent ആണ് here. Next one, next question. Which of these is the geographical indication here? You can see the 5 option. What is the GI here?
Orange.
Yes, super. It's Nagpur orange. Now, what does a trademark protect? Invention, work of art, logos, names and brands, a secret formula. Yes, logos, names and brands. Very good. Now the next question. How long can a patent last? 10, 20, 40, 60 years. So yes, very good, 20 years. The patent is valid for 20 years. Now, next question. If you write an original story, what type of IP gives you the right to decide who can make and sell the copies of your work? Copyright, GI, patents, designs, trademark. So what is the answer here? Yes, copyright. Super. Many have answered. Now the next one is, imagine a cricketer sets up his own company to sell his own range of clothes. For a cricketer or a company open a clothing company. What type of IP can he use to show that the clothes are made by his company? So now he wants to show that the clothes are made by his company. So what is the IP he can use? Is it copyright? Is it GI? Is it patents? Design, trademark? Super. It's trademark. Many have answered. Very good. Now, if a company develops a new technology that improves its main product, what type of IP can they use to stop others from copying their invention? Copyright, GI, patents, designs, trademark. For a new technology. Yes, patent. That is the answer. Very good. Now, that was the end of the session. You all participated in the quiz very nicely. Thank you. Thank you for the patient hearing and participation. So, if you have any queries, you can actually ask me, or you can type the same in chat box. Whichever is comfortable to you. You type in the chat box. Any questions?
Thank you, Anjali ma'am. Thank you very much for your crystal clear explanation and the interactive session. ആർക്കും എന്തെങ്കിലും ഡൗട്ട് ഉണ്ടോ ചോദിക്കാനായിട്ട്? പുതിയൊരു ടോപ്പിക്കാണ്, നിങ്ങൾ പലരും കേട്ടിട്ട് വരുന്നതേ ഉണ്ടായിരിക്കും.
You can actually go through the various things. You got to know there is something called patent designs. So you can in detail watch it. If you get any doubts, still you can put a mail to this ID and you can ask your question. Okay.
ആർക്കും എന്തെങ്കിലും ഡൗട്ടുകൾ ഉണ്ടോ? ഉണ്ടെങ്കിൽ ധൈര്യമായിട്ട് ചോദിക്കുക. അതർവൈസ് മാം ഡൗട്ടുകളൊന്നും ഇല്ലെന്ന് തോന്നുന്നു. നമുക്ക് വോട്ട് ഓഫ് താങ്ക്സിലേക്ക് പോകാം. ഐ വെൽക്കം മെറീന മിസ്, IQAC കോർഡിനേറ്റർ, ഫോർ ദ വോട്ട് ഓഫ് താങ്ക്സ്.
Good morning, everybody. I hope I'm audible. Can you hear me?
Yes, yes.
I hope this webinar was as informative and useful for all of you as it was for me. Our resource person, Anjana Haridas, was very clear and concise, and I'm sure this webinar was very informative for all of you. I would like to thank Ms. Anjana Haridas on behalf of IQAC and Institution Innovation Council of St. Mary's College. Thank you, Madam. I would like to thank our principal, Dr. Punan Kurian. He is a very strong support and motivates all of us to organize many programs for our students as well as for the other participants. Thank you, sir. But most of all, I would like to thank Mr. Tony Francis, of Assistant Professor, Department of Chemistry of our college, for his dynamic leadership and interest in organizing this webinar. I would like to thank all my colleagues who have participated in this webinar. Moving on, I would like to thank all the participants who have joined this webinar. Thank you and have a nice day.
താങ്ക് യു മെറീന മിസ്. ഞാനൊരു ലിങ്ക് ഇവിടെ പോസ്റ്റ് ചെയ്തിട്ടുണ്ട്. അഞ്ജന മാം, ആ ലിങ്ക് മാം അയച്ചെന്ന ലിങ്ക് തന്നെയാണ് പോസ്റ്റ് ചെയ്തിരിക്കുന്നത്. ഓക്കെ, അപ്പൊ നിങ്ങൾ കറക്റ്റ് ആയിട്ട് ഫില്ല് ചെയ്യുക. നിങ്ങളുടെ പേരും അതിൻ്റെ അകത്തുള്ള 3-4 ക്വസ്റ്റ്യൻസേ ഉള്ളൂ. അത് കറക്റ്റ് ആയിട്ട് എല്ലാവരും ഫില്ല് ചെയ്യുക ഫോർ ദ സർട്ടിഫിക്കറ്റ്സ്. ഓക്കെ, താങ്ക് യു എവരിവൺ. താങ്ക് യു അഞ്ജന മാം.
Thank you all. Have a nice day.